Hi, I'm Attorney Samantha Gordon with McIntyre Elder Law, and today I have our Director of our Charlotte Probate Department, Alexa Upchurch. Hi, Alexa.
Hi, good morning.
How are you?
I'm doing great this morning.
Awesome. We're here today for another Sync and Synergy team talk where we're going to be discussing all about probate, but specifically how it relates to married couples. So, Alexa, if you can kind of give us an introduction as to what we're going to be discussing, and then we can go into it.
So a lot of folks, when they are married to their spouse, they think that everything transfers when that party passes away, even without doing a lot of planning. So what we're discussing today is some of the outliers that could possibly exist and how good estate planning can help in that probate process when your spouse passes away. Today, we're going to go over kind of what kind of assets might be in that outlier feature and how you would handle that. What kind of filings through the court potentially would you do to transfer those assets? Some folks don't have any assets that they need to transfer because they do fantastic planning and they've got everything in order. But there's a lot of outliers, and that's what we're going to cover today.
Yes, thank you, Alexa. So first, we're going to discuss the difference between intestate and testate. So intestate means that you do not have planning documents in place. Testate means that you have documents in place. So Alexa, if you could kind of go over just what you've seen, maybe some issues that you've seen when one spouse has passed away, or maybe something that you've seen where you're like, that's great, you did it. Like, so happy for you.
Yeah. Testate versus intestate, as she mentioned, can affect the components when you're doing that transfer. So some of those outliers would be like a vehicle. A lot of folks have vehicles. They think that by putting that vehicle in both of their names, it will automatically transfer to the other party that still lives. But unfortunately, DMV is very particular in North Carolina, and that is not the case. So that spouse, that's the surviving spouse, would only have a half interest in that vehicle. And there is planning that you can do to take care of that with the DMV. One of the easy ways to do that would be putting a new title together that says right of survivorship to that other party. You can do that for spouses, but you can also do that for, let's say, a relative. So it's entirely up to you if that's something you want to do prior to potentially someone passing away. Now, today we're talking about spouses, but again, that can be done for other parties. One of the things that also comes up a lot of the time is checking and knowing if there is any kind of residual transfer or named beneficiary on insurance policies. Some folks will have an insurance policy they set up years and years and years prior, and then they discover that unfortunately that party that they named has passed. And in insurance policies, if that party is no longer alive that you named as your beneficiary, it usually rolls to the estate and it has to run through their estate. So checking your insurance policies is also incredibly helpful.
And a lot of the times, people will set up insurance policies for the hope that that will be paid out for burial expenses.
True.
So if your beneficiary had passed away and you never put a contingent beneficiary, now it has to go through the estate, that money cannot be used for burial expenses.
Absolutely.
So that's, we see that a lot, unfortunately.
Yeah, you see that a lot, and folks think that they're doing fantastic planning, but as you age, as time progresses, even if you have a will, a trust, or anything like that, those two items can be outliers because that's a contract between you and that entity.
Intestate succession means that an individual died without a will. So intestate succession laws apply. And in North Carolina, contrary to belief, like Alexa said, your spouse does not inherit everything that you owned when you pass away, if it's in your individual name and the spouse is not named as a beneficiary or right of survivorship. What will happen is the spouse is entitled to the first $60,000 of your estate, but if there are children involved, then the remaining property can be split between the spouse and the children. If you have minor children, that presents a big issue. So we really want to think about when you're married and you may have separate assets, you have a plan in place that is going to ensure that if something happens to one of you, the assets safely and also easily pass to the surviving spouse. It gives less of a headache to the surviving spouse. It also ensures that your assets are protected and that your spouse now can handle those assets for you. It's very, very important to make sure that you have a plan specifically because of North Carolina laws that are in place.
Mm-hmm. And speaking of North Carolina laws, we do want to reiterate for folks that might think that North Carolina would recognize common law marriage. That is not the case in North Carolina.
Not in North Kakalaki.
That's right. So you have a situation where you can't make the assumption just because you are residing with that person for many, many years that the law is going to recognize that as a valid marriage. It is not. Not in North Carolina. Now, other states, yes, but not in our state. So that is something to keep in mind, and that's why you need to do good planning before your spouse passes away.
Definitely. And now let's talk about if spouse passes away, there are assets that were only named in this deceased spouse's name. What options does the living spouse have through the law in North Carolina?
Through the law. So let's say there are these outliers like we mentioned before. There's a couple different approaches that you can do in North Carolina. One of the easiest and most used is the spousal allowance, which is a special type of filing that the court has set up for the surviving spouse so they can transfer assets quickly and easily that are under a set amount. So right now that set amount is $60,000. So if the asset is worth up to $60,000, you can transfer that asset by doing this filing. And you can also add to it over time. Now there's a strict guideline that this filing has to be done within 1 year of that spouse passing away. You'll also have to provide to the court that you are that actual spouse. So you're going to have to sign some documents and do a filing with the court to prove that you're that spouse. They won't just take your word for it. You'll also need to know what those assets are that you need to transfer. So all of that information is very important, but that is the best way to, and quickest way, to transfer assets.
And a quick tip, just to interrupt, a quick tip would also be to make sure that you have an inventory of all of your assets while you're alive.
Absolutely.
Whether you have an estate plan or you don't, you should have an estate plan, but if you don't, you should always have an inventory of all of your assets because there's not just a database that we can just go and look up all of your assets to know what you got. If so, there would be a lot of hacking and probably not a good thing. So you want to make sure that you have an inventory not only for your surviving spouse, but any other family members that may need to know what assets you have. So vehicles, bank accounts, investment accounts, retirement, life insurance, all of that should really be listed out. And it really, really, really is going to help your loved one and it's going to guide them through the process of making sure that things are transferred appropriately.
Absolutely. Yeah. Pre-planning is key because especially when we have, a situation where it's a first marriage or even a successive marriage that maybe your partner has been divorced several times.
Or your blended family.
Yeah. Having that estate planning in place and having an itemization of what those assets are will really help yourself through that process because you're going through this and there's a lot of emotion going on, a lot of turmoil that's happening in your life, and you want to know exactly how to move through all the things that you would need to do to transfer assets and be whole again as much as you can after that party passes away.
Definitely. I would also like to kind of transition this a little bit into maybe a touchier subject. Maybe things are not going well in the marriage. And we have one spouse that's coming to us and they do not want to include their spouse in their estate plan. And when that happens, I need to let them know that in North Carolina, you cannot disinherit a spouse. There is a specific statute within our laws that is called an elective share. share. So if you could go in with that and let our viewers know what an elective share is and why can't they disinherit their spouse. One more thing, sorry, subject to if there's no separation agreement in place that says that they've disinherited each other from their estates or there's no finalized divorce. Just wanted to put that caveat in there.
Absolutely, yeah. There are lots of layers during the process. But in North Carolina, a spouse is seen as having the ability to claim a share of all the assets that are out there up to a certain dollar figure, okay? So even if the assets were to transfer upon death to a child or to a family member and completely leave nothing to that spouse, if there is no agreement in place, they can still petition the court and get a share of those assets. And
based on how long they've been married.
Correct. Yeah. So there's a lot of layers to that process. And that is something that is a potential way for the spouse to come forward and see themselves through, especially in a multiple marriage type situation where your spouse may be on their second or third marriage. So sometimes that happens. Another factor that I wanted to bring up when we're talking about these kinds of situations is divorce. A lot of people don't realize that if they have a will and the will was, say, done 20 years prior and it lists the name of a spouse in that will and then they subsequently get divorced, that divorce is recognized by the court and they cannot get whatever that bequest is in that will.
But other than a will, beneficiary designations don't change if you get divorced. So if you have a life insurance policy and your ex-spouse is still the number one beneficiary on that life insurance policy, well, now your ex-spouse from 20 years ago is going to get that life insurance policy if something happens to you. In addition, powers of attorney also. So financial power of attorney, healthcare power of attorney, you appoint someone to manage your financial affairs for you while you're alive, or your health decisions while you're alive if you cannot make your own health decisions. If you've named your ex-spouse in that document and you have not changed that, you end up in the hospital. Well, your ex-spouse may have the ability to make medical decisions for you because you did not change that document. So keeping that in mind as well with divorce.
Absolutely. Yeah, and this goes back to, good estate planning, number one. Number two, planning with all your insurance, planning on all of the assets that you have. So that's a trigger moment for you during the divorce process that you need to start making some serious changes and update things. Otherwise, if it's forgotten, that can be a real problem to your existing spouse because now they're kind of at a loss as to how to handle things. Yeah, absolutely. Yeah. It's just very frustrating process. What other ways can we transfer assets? Let's say you have over $60,000 net worth of assets that are in spouse's name that you as a survivor need to get a hold of. There are other types of formats that you can go and do filings with the court, one of which is called a small estate or estate that is under a certain percentage. So in North Carolina, and this may change over time with legislation, that value right now, I believe, is set at, is it 30? I believe it's 30 for the surviving spouse. So there's a net cap of 30. Now, what some folks will do is they will take their spousal allowance, they will file that, and then they will combine that for the difference sometimes to handle whatever the other assets may fall out as an outlier to that $60,000 cap. So that's one way they can do it. They can also do a great way to transfer those kinds of assets if there's no direction in the will. Alternatively, barring this, they can do what's called a summary administration. So that is a filing with the court. Again, to transfer assets, you would need to know what all the assets are and prove to the court what they are and how they're held. But that is a once and done type thing. That would be a great alternative for spouses that need to transfer assets. They do have to make sure that they're handling all creditor claims, though, because they are subject to creditor claims. So one other thing is claims. How do we handle those? What are those? How do those affect that spouse?
Medical bills. What happens if my spouse died because they were in the hospital for a month?
Right, exactly. So in North Carolina, again, they have these provisions for the spouse. And when you do a spousal allowance, this is why it's key to do this, they are protected from creditor claims up to a certain dollar figure. So that again is at that cap of the $60,000. So the spouse, when approached by a creditor, can talk to that creditor and say, look, I filed my spousal allowance, I'm protected under North Carolina law, and negotiate with the creditor.
Or we can tell them that.
Or we can tell them that, exactly. Or we can tell them that. But essentially they have that protection in place. It's very important, therefore, to get a spousal allowance done when your spouse passes, because that is going to set that protection in place for you. Now, a lot of people get confused. We keep talking about spousal allowance. A lot of people get confused about spousal allowance. What does that mean? They think they're going to get money from the government. No. Unfortunately, a spousal allowance is an allowance afforded to that spouse to transfer assets. It is not the government giving you $60,000. It is you transferring assets in your spouse's name up to that amount. So I wanted to clarify that. A lot of folks get very confused because they see allowance and they think, ooh, something is being transferred to me. Yes, but only what your spouse had is being transferred to you, not additional funds. So that is something to also think about. One more thing that I would say that the spouse needs to be aware of is there is a Social Security benefit when a spouse passes that you can file for. It is not a lot of money. It's a little bit of money, and it obviously will change from time to time as the years progress through legislation. But a spouse should also take advantage of that and do a filing through Social Security for that benefit.
Definitely. Well, thank you so much, Alexa.
Thank you.
I really enjoyed this. I felt like I got a little bit of a refresher. Thank you so much. We would love to offer a free consultation for you and your loved one to discuss probate, pre-planning, estate planning, and how to make sure that we can help protect your assets and help you understand how to protect your assets. Give us a call at 1-888-999-6600 or visit our website at mcelderlaw.com/scheduling.